We're all anxiously awaiting what happens out of the Southern District Federal Courts, where a judge heard the challenge against Illinois' gun and magazine ban last week. But we've got some movement in the Northern District Federal Courts, where a 7th Circuit Court of Appeals panel has denied a motion from plaintiffs suing the city of Naperville and the state of Illinois over its gun ban to have a preliminary injunction in place while they appeal to the 7th Circuit Court of Appeals. So just to be clear, this is not the state-level courts. These are the federal courts, all right? The state-level court still has their deals going on where they've got to hear the gun ban challenge from State Representative Dan Calkins and all the questions about the, judicial integrity with the Pritzker donations to those state Supreme Court justices. That's separate from this. The 7th Circuit Court of Appeals is federal, and it includes the Northern District, also includes the Southern District of Illinois federal courts. Last week, we had the Southern District cases, 4 consolidated cases from the Illinois State Rifle Association, National Shooting Sports Foundation, Federal Firearms Licensees of Illinois, and also the case out of Crawford County. Those 4 cases consolidated in the Southern District. That was heard last Wednesday, right? Now, the Northern District case comes from a gun store out of Naperville that was suing Naperville to block its ban, but that was filed last fall. And since it was already progressed, they amended their complaint to include not just Naperville, but also the state of Illinois' ban after it was enacted January 10th. So this is the Northern District case. In February, a Northern District judge sided with the state, saying that the law was constitutionally sound. In federal court, the plaintiffs in that Naperville case appealed to the 7th Circuit Court of Appeals, where they then have a motion to halt the law pending appeal. So yesterday, the 7th Circuit Court of Appeals denied that motion for a preliminary injunction, keeping the law intact while they continue their appeal in the 7th Circuit Court of Appeals. It's not a ruling on the merits of the case. It's just simply saying, no, we're not going to halt the law while the appeal goes forward. So the appeal still goes forward, but we've got some reaction from the gun control lobby. G-PAC talked with John Schmidt last night after this ruling came down, and he talked about where they stand on this. And here's a bit of an overview.
Well, the 7th Circuit Court of Appeals flatly rejected the effort to enjoin the statute at this point. The Naperville gun dealer who challenged the statute initially had lost in the court below, and he has the right to appeal, and that appeal is going forward. But he then went in and tried to get the court to act immediately to stop the statute from continuing its effect, and the court shot him down. They didn't even seem to feel it was necessary to give an explanation. It's a flat one word, motion denied. So it's a good result for those of us who support the statute. And we'll go forward now and have a full-scale appeal still in the 7th Circuit, but the statute remains in effect.
So again, a full-gone appeal still going to happen in the 7th Circuit Court of Appeals with this Naperville case. Now, what's interesting is the 7th Circuit Court of Appeals is over the Northern District of Illinois and also the Southern District of Illinois, where you have that case that was heard last week. And when that judge issues his ruling in the Southern District, who knows? We're all anxiously awaiting that. But what happens if he sides with the plaintiffs there and blocks the law? It's going to be interesting. John Schmidt from G-PAC providing a bit of commentary as to what that's going to look like.
It's very unusual to have this many different lawsuits pending against a single state statute. I counted up the other day. I think I was up to 12. But as the one that has moved along the fastest and has reached a decision on the merits is here in Chicago, where there was a case against brought by a Naperville gun dealer. He actually originally brought the case because Naperville had passed a ban on assault weapons. And then when the Illinois statute was passed, creating a statewide ban, he amended his complaint and challenged the state ban. That case was decided against him and in favor of the Illinois statute. Very strong opinion. Judge Kendall said, really very unequivocally, the statute is constitutionally sound. So that's the one decision we've had on the merits. Actually, it's not only the only decision here in Illinois, that is the only decision in the country on an assault weapons ban that has been decided since the Supreme Court last year fundamentally changed the way courts decide Second Amendment issues. So it's a very important decision. That one is now up on appeal. to the Federal Court of Appeals. And what happened today was that the effort to get immediate relief, which the gun dealer tried for, failed. The court said no immediate injunction, so that's going forward. In the meantime, or really simultaneously, we have another, actually I think total of 5 cases pending down in East St. Louis, brought by various, particularly the national gun rights groups. I think they made a decision they were better off in Southern Illinois than in Chicago, so they filed lawsuits down there. That case went to a hearing just last week before a district judge in East St. Louis, and he will be deciding that case. So he is not bound by the decision that was reached earlier here in Chicago. So he could come out differently, but he is in the Seventh Circuit. So whatever the Seventh Circuit does now on appeal from the Chicago case will also be binding on the judge in East St. Louis. How the timing of all that will work out,
who knows, he says. It's kind of interesting, again, to take a step back and see what's possible here and the kind of different rulings that could come out from the Northern District back in February, from the Southern District, which we still have yet to see, and how the Seventh Circuit Court of Appeals is going to handle that. But again, the timing is anybody's guess.
But they're all moving along, and so far, the cases have upheld the statute, and the statute remains in effect.
Again, I'm sharing a bit of a conversation I had with John Schmidt. He is on the board of the gun control group G-PAC. They work towards preventing gun violence, and they support a ban on semi-automatic weapons. But I asked him also, what's his definition of the Bruen decision, the case from the New York State Rifle and Pistol Association versus Bruen that led to that precedent from the U.S. Supreme Court that people say change how courts are to determine the validity and the constitutionality of certain types of gun laws. And here's what G-PAC's take is, at least his take, John Schmidt's take on the Bruen decision.
Well, I think our take is clearly the Bruen case changed the way courts decide these cases. Before Bruen, the prevailing view in the courts of appeals was that you apply a balancing test. You look at the extent to which the statute interferes with any rights to bear arms, and then you look at the benefit of the statute and you weigh them against each other. The court in Bruen said unequivocally that's no longer the way we decide them. You look first at whether there is, in fact, an impact on the right to bear arms. And, a threshold issue in the Illinois statute case is whether high-capacity magazines are arms at all. We had a judge in Rhode Island last year who said unequivocally, a magazine is not arms. You can't fire a magazine at anybody. It's an attachment. And the Second Amendment protects the guns themselves, doesn't protect the attachment. So you have those kinds of questions. If you decide that the statute does, in fact, impair the right to bear arms, then under the Bruen case, you have to defend it historically. And in the Chicago case, Judge Kendall said, in fact, we have a long historical tradition in this country of banning dangerous weapons. And she went back all the way into the 18th century bans on various types of clubs. And then she went on through Bowie knives, and she went on through machine guns. And she said this statute, she thinks, falls within that historical tradition. But that's the question now under the Bruen case. If you decide that the statute is in fact impairing the right to bear arms,
and he says that there's also just the conversation in the courts about that history and tradition. Again, conversation I had yesterday with John Schmidt from G-PAC.
You can ban dangerous weapons, and you can make that judgment based upon current conditions and current weapons. Some people argue you have to get into a much narrower kind of category. Was this particular type of weapon banned historically or not? My own view is that's a ridiculous way to think we would now decide these cases, but there are some people who think that's the way we're going to do it. It's all just making its way now through the courts. These are the first cases involving an assault weapons ban since the Bruen case was decided last year.
So, that's their definition of Bruin. He's also talked about how magazines aren't considered arms. That's something that very much is part of this debate as well, as there's continued challenges against Illinois' gun and magazine ban. Again, just to reset before my last question to John Schmidt, the Seventh Circuit Court of Appeals has denied a motion for a preliminary injunction to be issued pending appeal in the Northern District Naperville case, where a gun store is suing Naperville and Illinois over its gun and magazine ban. A judge in February sided with the state, saying that it's constitutionally sound. The plaintiffs went up to the Seventh Circuit Court of Appeals, and the Seventh Circuit Court of Appeals denied the plaintiffs' motion to block the law while the appeal goes forward. The appeal still goes forward. It just goes forward while the law is intact. What happens with the Southern District? If they grant a preliminary injunction, would that block the law statewide while that goes to appeal in the same appellate district, the Seventh Circuit Court of Appeals? Again, fascinating to watch how this is going to go play by play. We'll be covering it all for you, I promise, from all angles, including talking with those who support the ban on semi-automatic weapons. John Schmidt from G-PAC, I asked him a question I see all the time, or a statement I see all the time, and even on the chat on YouTube, shall not be infringed means shall not be infringed. What's his response to that?
Yeah, but it's the right to bear arms that can't be infringed. So the threshold question is, what is the right to bear arms? Honestly, nobody can seriously argue that banning the particular types of semi-automatic weapons that are banned by the new Illinois law, or banning high-capacity magazines, keeps anybody from bearing arms. You can still buy all kinds of semi-automatic weapons. You can buy magazines that carry up to 10 rounds for rifles and 15 rounds for handguns. So are we impairing the right to bear arms because we limit the ability to buy certain types of weapons? I think my common sense answer to that is no, but we have to see ultimately what the Supreme Court says about that.
Another twist, another turn as we continue to track what happens with Illinois' gun and magazine ban and the legal challenges against it. Again, that's just the federal court stuff. That's not even the state Supreme Court stuff, there's plenty more to talk about that. So we'll be tracking this as we do each and every morning on WMAY. Thanks.